Section 3 tells you that you must address yourself to Article 10 of the Constitution. And what are you addressing yourself to Article 10? Article 10, subsection, clause 1, provides that Article 10 binds all state organs or even persons whenever any of them is either implementing the law, legislating the law, or formulating in a policy. In this case, Your Honor, you are implementing the law. And therefore, you are bound by the provisions of Article 10, which lays down the national values and principles of governance. Among those values, Your Honor, is a value of human rights. That human rights binds you. And that is why Section 8 of the Magistrates Court Act, in cognizance of the fact that you are bound by Article 10, has deliberately given you that jurisdiction. Because it is not possible, therefore, for the Constitution to say that Article 10 binds you holistically without any possibility of waiver, and then you are told that you cannot determine a threat, you cannot determine a denial, you cannot determine a violation. Having said that, Your Honor, Article 10 also invites you to look at the rule of law. And also the question of social justice. And the principle of equality and equity. That is therefore to say, Your Honor, and I want to associate myself with the submissions made by senior counsel, is there equality, equal application of the law, granted the circumstances and the summation that he has made, because I consider them to be legal arguments. Number 2, Your Honor, the application of Article 10 invites you to look at the question of discrimination under Article 27. Because Article 27 falls within Article 10, where you are mandated or commanded by the Constitution to observe human rights. And therefore to say that, Your Honor, when you retire to make our application to the objection of taking plea, this plea does not conform to the dictates of the new Constitution. That is one ground of the objection. That it is not possible for you to ask Honorable Jane Kihara to make a plea that will be unconstitutional for failure to conform to the dictates of Section 7. That's one link of our argument. The other link of our argument is that the same does not disclose an offense. Those are 2 grounds. That if she was to make, or she was to plead to this offense, one, she does not even understand what offense is actually facing her. Because even if we were to make an assumption for purpose of argument that Section 94, subsection 1, that it was in conformity with the Constitution, is it just the proviso that Jane Kihara, Honorable, offensive conduct offensive conduct conducive to breach of peace? This proviso of the law must be backed by particulars that speaks to that offense. We therefore submit that the particulars pleaded herein do not speak to the purported or to the alleged offense. These particulars falls within the provisions of Article 33 of the Constitution, the freedom of expression. To admit this charge, therefore, Your Honor, this court would be rising up to the occasion of limiting her rights. And the limitation of these rights, Your Honor, under Article 24, the court has created a test that it must be justifiable for you to limit. It must be justifiable in a free, open, democratic, and civilized society. If that then would be the test and granted her status of members of parliament, would the taking of this plea not amount to the limitation of that particular right? And would that right be a justifiable one in a democratic society? A free society such as this one? A civilized society such as this one? That was not the intention of the legislation. That was not the intention of the enactment of the 2010 Constitution. And then even if she were to plead, Your Honor, even if she was to plead, that she made these remarks, Your Honor, would this conform to the provision of Article 50, Clause 2, Paragraph 4? And that's the doctrine I love speaking about, the doctrine of nurum crimen sine lege, that you shall not be charged of an offense if the offense itself was not known in law. And the argument that the offense is not in law is due to the fact of the jurisprudence that has emerged following the enactment of the new constitution vis-a-vis Section 7 of the 6th Schedule. That had it been to be brought to the conformity to that provision, this offense would not be existing in our books of law. If we had a proactive parliament, and not a parliament like the one that we currently have, this perhaps would have ceased being good law in our books. But granted the circumstances that Parliament itself has not amended this provision, that Parliament is too lazy to bring it into conformity with the provisions of Section 7, are we left helpless? Is it therefore that the DPP has the liberty to charge any other person just because Parliament has become negligent? Parliament has refused to legislate? You are called upon by Section 8 to rise up to the occasion in the event there is ineptness on one part of state organs. And besides that, I may invite my learned friend, Mr. Kihara. Article 10 places you in the same pedestal with the Parliament. Because this court and Parliament is bound up by that provision. So where there is ineptness and negligence on the part of Parliament, the court of law can rise up. In any case, the application of Section 7 vis-a-vis Section 8 of Section 7 to the 6th Schedule, vis-a-vis Section 8 of the Magistrates Court Act, can only be applied by this court, not Parliament. So we invite you, Your Honor, to find that there is no offense that has been disclosed by this particular charge sheet. The same is meant to achieve ulterior motives other than that which is contemplated to protect public interest. It is meant to preserve personal egos. It is meant to preserve at a certain equilibrium for which you do not understand personal emotions. Unfortunately, this is a court of law. If anyone feels injured by these particular statements, the recourse is not before you. The recourse is not to criminalize utterances that are constitutionally protected. When you retire, you look at Article 19, 20, 21, and 27 of the Constitution. I invite my friend.
Sorry, those provisions